Hey everybody, it is John here. Turn up the volume here. Anyways, hope you had a great week. I really appreciate the dialogue and the engagement, and the dialogue and sharing those experiences. Typically, with that first week discussion, I get a lot of either personal experiences or experiences from work, which is always great. So to be able to take those experiences, and I guess that's how healthcare is. Whether we work in healthcare or not, it can be typically a pretty personal environment based on our own personal experiences, and so um, we typically, with a discussion question like that, have an experience that's ready to share. So thanks for that. Appreciate the thoughtful posts this week. So, anyways, I wanted to introduce week two to you, and go over a little bit. I think you remember from last week's video, we talked a little bit about how to analyze the legal issue that we'll be discussing largely in this class. And so we'll be going over that again, and we'll repeat that throughout the course. So again, if you have any questions, let me know. I did get a handful of questions this week, which is great. Hopefully you considered my responses timely, because I don't like to leave you hanging. So so please feel free to reach out to me, whether by text, phone, email. It doesn't matter. Let me know. I just want to be able to help you get some out of this class and help you get some value out of the things that we're discussing. So this week in your reading, there's a bunch of discussion about the legal system, and so if we can go through that. I think that's important background information for some of the things that we're discussing, just in terms of context, really, but not super material to the things that we'll be discussing, healthcare specific things. I'm not a litigator. I don't do a lot of litigation. I've been to state court a couple of times. Really largely not healthcare related issues, and back when I was a brand new associate, I haven't really done that in a long time. I do litigation now, but it's largely administrative litigation, meaning it's not in what you would think of as a court. It's largely with federal or state agencies related to either government reimbursement issues, Medicare or Medicaid, or I have a lot of cases right now with both Medicare and Medicaid in Colorado. Like I told you before, physician disciplinary issues I've handled, state licensing board issues with respect to healthcare facility licensure, or provider number suspension or revocation issues. So those are handled administratively. I apologize. I'm trying to situate this so the lighting is better. So, those procedures are governed by statute, state, federal statute, regulations, rules that these agencies are authorized to publish and issue. If you have any questions about that, please feel free to let me know. What I do want to bring your attention to is the discussion on page 40 of your text about negligence. So I want to talk about negligence a little bit. So medical malpractice or professional liability cases, whatever you want to call them, they're really just negligence cases. So if you just remove yourself from healthcare for a second. So if you were in a car accident and the other person was negligent in driving, sometimes you would bring a civil lawsuit against that person. And your stated cause of action would be negligence. So, negligence, just general negligence claims, there are 4 elements. Was there a duty? Was there a breach of that duty? Was there causation, meaning did the negligent act cause the harm? And was there harm? Were there damages? And if so, to what extent? So those are the 4 elements. I think your text calls them the four Ds, I believe. Duty, dereliction of duty, and I don't remember the other two. But regardless, there are four elements. You'll have to look those up. But um, so that's just general negligence. So go back into healthcare in the medical malpractice context, professional liability context. Those are really just negligence cases in the medical space, and so the elements are basically the same. So, like in a medical malpractice case, you have to show that there's a duty, and your text talks about what gives rise to the creation of that duty, and that's really the formation of the physician-patient relationship. So once that physician-patient relationship is formed, there's a duty to exercise reasonable care. So that's the first element. The second element is a breach of that duty. So did the provider deviate from the standard of care in any way? So we'll be talking a lot about standard of care throughout this class. So in order to determine whether the provider, physician, whoever deviated from the standard of care, you obviously have to know what is the standard of care. And this is an issue that's really highly litigated in any sort of malpractice case, because the standard of care arguably could be different based on the provider, based on the geographic location of where it occurred. So for example, the argument that a plaintiff, patient who's injured, allegedly injured, the argument that the plaintiff would make is that the standard of care is the same everywhere, right? So whether it's in a hospital, an urban hospital in the middle of Manhattan, or if it's in a rural healthcare clinic in Western Kansas, the standard of care is the same. So let's say this plaintiff is in Western Kansas, is injured, files a claim of medical malpractice, and the question of what is the standard of care comes up, and they would argue, well, it doesn't matter where you are. The providers in Western Kansas should be held to the same standard as the providers in New York, because everyone has access to the same information, the education is the same, et cetera, et cetera, et cetera. The defendant, hospital or provider, whoever, would argue that's not true at all. We're a rural healthcare clinic in Western Kansas. We don't have access to the same resources as some hospital in New York, and so there's this back and forth in terms of what is the standard of care. So once that standard of care is established, then the question is, did the doctor deviate from that standard of care? So that's when you look at the facts, apply that to the rule in this case being the established standard of care, and then you come up with your analysis. So the third element is causation. And this is really just based on the facts. Based on the facts, can you reasonably ascertain that the negligent act, actually caused the harm or the damage? And the last element is damages. So was the patient actually harmed? If so, to what extent? And this is where you get into how young or old the patient is. What's the past medical history of the patient, in terms of the extent of the damage that this negligent act caused. That's kind of where all that comes in. So, anyways, here's the key that I want you to make sure that you walk away from this with, and that is, liability does not. So if you go in for a medical procedure, something goes wrong, that doesn't mean somebody was negligent. So liability does not automatically attach when something goes wrong on the operating table, or when someone sees a physician. And almost all of you are in the clinical field and know that things can just go wrong because they go wrong. And that's why you have these elements that have to be established in order to show that there was medical malpractice. So that's really important because the plaintiff in a medical malpractice case has to show every one of these elements, has to prove every one of these elements by a preponderance of the evidence, meaning that it's more likely than not that, for example, the provider deviated from the standard of care. So the plaintiff has to prove each one of these elements in order to establish a viable malpractice case. If even one of these elements is missing, there is no case. And so this goes back to my discussion last week, which was the importance of analyzing every one of these elements. A legal analysis is similar to any sort of science equation. When I was a sophomore in college, I remember I had a physics professor. The professor was great. The class was terrible. I'm just not a science guy. But he would always, like every class, he would say, okay, you've got your formula here. You've got your values, your numbers. You just throw in the numbers, you turn the crank, and out comes your answer. And he'd always say that. Throw in the values into the equation, turn the crank, do your calculations, and out comes your answer. The legal analysis, to me, is no different because you have your rules. In this case, you've got your 4 elements of negligence. You got your rules. You got your facts. You throw the facts in, apply those to the rules, turn the crank, so to speak, and come up with your conclusion. So you can't, a lot of times with these assignments in terms of evaluating the legal issues with this Ituraldi case, what I see is, the doctor deviated from the standard of care, didn't meet the standard of care because of this fact and this fact, and therefore there was negligence. Well, it's not a full comprehensive analysis, and that's because that's just one element. That's one of 4 elements. And so you may not have facts for every one of those elements. You may not have facts of the damages, for example. Maybe you do. I don't recall in the case, but each one of those needs to be addressed. Each one of them needs to be analyzed in order to establish the legal issues. So, anyways, let me know if you have any questions about that. The only other thing I want to talk about is just to give you an idea of the legal environment. And how highly regulated it is. I just kind of jotted down a lot of the laws that I deal with in the healthcare space, both on the federal and state level, and came up with a pretty long list. HIPAA, which we'll be talking about, Stark Law, Anti-Kickback Statute, Medicare Conditions for Coverage, Conditions of Participation, False Claims Act, Beneficiary Inducement, Civil monetary penalty laws, Medicaid rules and regulations, state fraud and abuse laws, insurance regulations, privacy rules, patient abandonment rules, state licensure, accreditation rules, informed consent laws, Good Samaritan laws, living wills, DNRs, etc. Antitrust laws, facility-specific laws like academic medical centers, ASCs, SNFs, etc. And then FDA laws and regulations, which we'll talk a little bit about later on with respect to drug, medical devices, clinical research, which I've done a bit of, and things like scope of practice, medical records laws, things like that. So, we kind of cover the whole gamut of legal issues when it comes to healthcare. So many different issues. So anyways, that's it for this week. I look forward to the engagement in the discussions. And if you have any questions, please feel free to let me know. Again, I'll reemphasize this every week in terms of the importance and the critical nature of formatting the legal analysis the way that I just described in that IRAC format that's discussed in your text. So anyways, have a great week, and we will talk to you later. Bye.